Hey everybody, it's Derek Christensen from Legion Law, PLLC. I'm coming to you today and getting tripped up on this microphone cord. I'm coming to you today about this question I had from a client who was wondering what happens if a trustee or an executor of their estate passes away before the client passes away. So I wanted to address that, but before I do so, I wanted to let you guys know how to reach me. I am available by email or by website. Email is going to be my name, Derek, D-E-R-E-K, at legionlawpllc.com, or you can email, or you can go to my website, www.legionlawpllc.com. And there's a contact us page, so just feel free to reach out and schedule a time. So with that being said, let's dive right in. So the client has a trust in place, and they're worried that the trustee of the trust, the person who's going to make sure all the stuff happens according to the terms of the trust, that trustee is older than the client, and they're concerned that if they pass away, the client passes away, that the trustee will pass away before the client. So that's a valid concern because you want to make sure that the person who's in charge of all your assets after you pass away is someone you want, someone who's going to do it competently, someone who's going to make sure they don't make mistakes and cost your estate even more money than you already need to be paying. The last thing you need to do is pay Uncle Sam or other people like professionals to fix the problems of completely preventable issues. So that being said, the answer is a little bit more complicated. It just depends, and that's the unfortunate answer attorneys have to give quite frequently. But it depends largely on the content of the trust or the will that you're creating. So the trust, or at least a solid trust and a solid will address what happens if an executor is not able to serve or is dead before the person who passes away, the client, the principal, passes away first. So if that is what the trust addresses, then you will do whatever it says inside that trust. The trust document is pretty fascinating in the fact that there are a default set of rules in Texas, and if your trust deviates from those default rules, they will defer to the trust. The trust rules over the law, unless you're doing something illegal. So that being said, if your trust says, John is in charge first, then Becky, if John can't serve, then Becky's going to serve no matter what the law says. So hopefully you work with an attorney who's asking you, well, what happens if John's not able to serve? What about Becky? And Becky needs to be inside the trust, needs to be in the document. Otherwise, Becky can't serve, at least not immediately. So what happens in a circumstance whenever John has passed away and you didn't put Becky in there? Becky's not mentioned at all in the trust document. You'll have to go before a judge, more likely than not. And a judge is going to tell you essentially who's just going to be in charge. They will select a family member, usually somebody who's close, somebody who knows the family circumstances. But this is the conversation I have with the client. There's some family members you don't want to be in charge. Some are less than trustworthy. Some just don't know how to do financial products and moving things around, and they're not organized. It's no fault of their own, but people are different. And you want to make sure that the person who's in charge of your estate does it correctly and does it to the most effective, does what you want. And there are plenty of people who won't do what you want or will do it ineffectively. So that's the major concern for people in this circumstance. You want to have backups, and you want to have a backup to your backup. So for my documents, I always have at least 2 or 3 backups for each position of anyone who's getting elected to do anything in my documents. And at the end of the day, I do say if all those backups can't serve, then a judge will determine, but we look for these criteria. So that being said, that's essentially how you approach it. It is a very common concern, and if you're older or if your trustee / executor is way older than you, then that's something you definitely need to keep in consideration. So that's it, essentially. There's your answer. So I hope you like it. But of course, that answer is all dependent on extenuating circumstances. Anything can be different, and so talking with an attorney is a very, very solid plan. I'm biased, I will openly admit that. But I think that talking with an attorney who specializes and reads these kind of things every single day will be able to give you context to what you're looking for. So if you're looking to reach out to an attorney like myself, namely if you're reaching out to me, again, you can reach me out to my email, Derek, D-E-R-E-K, at legionlawpllc.com, or my website, www.legionlawpllc.com. So that's it. We'll see you guys on the next one, and hopefully you enjoyed this video. So have a good day.